Welcome back. COVID-19 has become our reality. We're living in the midst of a pandemic. Now, legally speaking, how do we deal with this virus to ensure that we remain safe, that we protect our children, that we do the right things to ensure that the spread of the virus is curbed? We're going to explore this discussion from different angles, but especially from the legal angle, as we engage legal brain Samson Ladi Anyenene, who's a lawyer as well as host of Newsfile right here on this network. Samson, if you can hear me, a very good morning to you. Thank you for joining us.
Good morning, Ben.
Great. So let's hit the nail on the head. In recent times, you've seen what has happened in Parliament. You've had your own concerns with regard to parliamentarians not following the protocols, not getting tested, so to speak, and now Parliament having to shut down for some 3 weeks. We've also seen the court situation, and the court had to get to the point where social distancing and all of that, more stiff protocols were brought to bear. What is your take so far on these institutions and what they've done? Does it suffice?
Well, the big thing to look at now has to do with people who know they have COVID and are deliberately infecting others by still showing up at work, and also employers who don't seem to want to follow what has to be done, protect both those who are infected and those who are not infected, and they themselves, by insisting, as we have heard some of the reports, that their workers, employees, come to work even when they have tested positive. Of course, we have been told that people may also be scared in certain circumstances of the prospects of getting their jobs back if they made disclosures and were asked to stay at home. So we'll deal with the consequences of that. But the specific ones that you have referred to, well, it's very clear. As for Parliament, they haven't been an example for anybody at all to follow. And I have said the same constitution that gives you the right to privacy. You heard the members insisting to the speaker when the speaker did announce that they would be naming and shaming those that were infected and were still attending to the house. You heard the lawyers say that they have right to privacy and patient's confidentiality, and therefore the speaker had no right to put their names out. The speaker has every right, and I refer to the Article 18 of the Constitution, and it's very clear. The same Constitution that gives you the right is the same Chapter 5. You'll find that it takes away the right for the common good. It takes away an individual's right for the common good and for the protection of people's health, or public health. When it comes to that state, your individual right is relegated to the background. So if you have to comply with the law and you are not complying with the law, the speaker has every right to have named those people. I think in any other place where people who may be infected and are misconducting themselves, the employers have a right, if they cannot through any other means stop them, to, as it were, name them, if that is what it takes. But the more substantive matter of those who know they have it and are going out infecting others. We passed an EI much earlier,
right,
and it is still enforced, that requires isolation and mandatory quarantine and for treatment. If you breach that, you are subject to being punished by law. Now, the problem now is you have a situation where your isolation center may not be available, so people are being asked to, as it were, self-quarantine. the point of law here is, whilst the government by law has a right to take hold of you and imprison you in an isolation center, so to speak, but in the circumstances where there's no space, if a medical officer has asked you to self-isolate and you do not self-isolate because you have tested positive, you are breaking the law as well. And the law says that you could be liable to a fine of 600 Ghana cedis, too small, and then you may also go to jail for 3 months. That's also very, very small. But beyond that, I am thinking that it is time for government, for the president, to look at this again. There's a need for a second look, where if people are not going to report those who are spreading the disease knowingly to the police, so that the police will activate the criminal law, the section that talks about negligently causing harm. If you negligently cause harm to someone, you have committed an offense, and you may get to jail for 3 years. So that is also available. But in the meantime, what the president could do is to bring a new EI that will mimic a law that we have abolished. And that law we have abolished is the Towns Act. The Towns Act is specific in saying that if you have an infectious disease and you go out there in the public place or any other place and infect others knowingly, you are committing an offense and you'll be liable to pay 24,000 Ghana cedis. I believe that it is time for a new EI that will elevate it even beyond the individual, so that if for nothing at all, the punishment for knowingly still going to work or going out in the public and not isolating when you have tested positive should be actually the penalty that we are giving for not wearing a face mask.
Right.
Where you will pay either 12,000, between 12,000 to 60,000, or go to jail for 4 years or 12 or 10 years. And then also, we should target, the EI should target employers as well. So that if you're an employee and you know that your employer, if you're an employer and you know your employee has tested positive and you don't give them the space to self-isolate, or you yourself compromise and allow them to come to the workplace, you should also suffer the same punishment.
Okay, so Samson,
we may stop this.
Right, just hold it there. And I just want clarity. Did you say the Towns Act? Is that just for specificity? Did you say the Towns Act?
Yes, the Towns Act has now been overridden by the Public Health Act, 2012.
Okay, so
but
basically,
the Towns Act is the act I am saying. If we looked at section 40, 41, 42 thereabouts, we could use the language there, couch a new EI, because that language is specific. It says if you are suffering an infectious disease and you go out there and infect someone else.
And in this instance, it must be a deliberate act.
Yes, it must be deliberate.
Right.
And the deliberateness or the willfulness is in knowing that you are positive. And knowing that once you are positive, you are required either to be quarantined, which is mandatory, or if the state doesn't have a space to accommodate you because of the current circumstances, isolate or quarantine. I mentioned in the Public Health Act, section 12 thereabouts, if a medical practitioner issues you the instruction and you disobey it because there's no one policing you, you are committing an offense, except that the sanction is too small. There's actually no deterrent to pay 600 Ghana cedis or go to jail for 3 months. And I'm saying we can change all of that, put it in a new EI, which is dedicated to answering the question of this new reckless behavior of people who know they are positive and yet are not isolating, are not in quarantine, and clearly are infecting others. We have heard stories that are harrowing, stories that are very disturbing, where people have infected others, including one that we have heard about, a pregnant woman who had to be delivered early because a colleague at work, recklessly has infected that person.
Right. Very sad incident there. But if I understand you properly, then retroactively or retrospectively, though I know the law likely wouldn't be applied in that way, then we could say, for example, that the actions of Carlos Ahenkorah sometime last year when he stepped out during the electoral period, that would fall into the category you speak of, wouldn't it?
In Carlos Ahenkorah's situation, there were places of quarantine, and he actually was supposed to be in the faith. And so once he moved out, he had breached that provision, and he was liable if we were serious about it and had pursued him. There's no retroactivity, and there is no, as we say, no time lapse on crime. Crime is crime today, will be crime in the next 100, and it can be prosecuted. It's not like other offenses that have limitation after a certain period. If you don't take the matter on, then it dies and you have lost the opportunity.
Would that extend to the actions of members of parliament who suspected or knew they were positive and yet still attended to the business of the House?
Exactly, it does. The EI 62, 3 or 4 was very clear that once you test positive, there ought to be isolation, quarantine, treatment. But we know we have a problem now because you may not have a place where the state will put you in prison you and take care of the situation. That's why we say self-quarantine, self-isolate, so to speak. Anybody who has tested positive is told and is aware. Nobody can claim they are unaware that once they test positive, they are supposed to isolate and go into treatment. And they know that once you go out, step out in the public, you clearly will be infecting other people. So that is what I say. We need special EI focusing on that issue to take care of it. And the president can do it 1 minute. Just get his professionals to draft the thing, and he signs it, and it becomes law. And it is punishable under the Imposition of Restrictions Act, which punishes with 12,000 to 60,000 and 4 years to 10 years imprisonment. That would be a good deterrent. Of course, there is also the opportunity for people to either report to the police if they know that they have actually been infected by somebody else, so that the police can take up an action generally under our general criminal law under negligently causing harm, which can attract up to 3 years.
Okay.
The people could also, on their own, take up a civil suit. But of course, that comes with expense. That comes with cost.
Right.
You don't want, at this time, to be saddling people with...
Let me delve into the punitive measures with you, especially for organizations who know that some of their staff have actually turned out positive. I pose that question. I bring us back to it because I know a lot of people who keep telling me, oh, there was a random check, and then we found out that, X number of people were positive. And sometimes some people are asked to go home. Sometimes all of them are asked to go home. But what sort of punitive measures do you feel should apply to such organizations as a deterrent?
Yes, so I'm saying we clearly need to take care of that situation. And it can't be taken care of by the stroke of the pen of the president in the creation of an EI that makes provision for it. And it's so
Yes, but I'm asking specifically, when it comes to the individual level, we know what applies, the fines and all of that. I'm asking, in terms of organizations, what are your suggestions? What would you proffer by way of punitive measures so they can actually feel the effect?
Yes, exactly my point. That you don't only punish the individual, but let the punishment extend to the organization, so that an employer, an EI will say, an employer who knows an employee has tested positive and still allows them or permits them onto the premises of work, or disallows them from taking time off to self-isolate or go into treatment, is equally guilty. So you punish the employer as well. If we did it that way, we will have, a sort of a two-pronged approach to dealing with the reckless behavior. This is insane. This is heartless.
Right.
It's so wrong that you have tested positive and you don't want to stay away and protect others.
Okay. Samson, I want to wrap up with you with regard to what transpired in the Supreme Court yesterday and what you're looking forward to come tomorrow. But before that, if you were consulted on what you are proffering now by way of a new EI with regard to the measures to curb the coronavirus, would you be willing to actually allow your brains to be picked? I just want a yes or no answer on that.
The thing you need about it is that this is science. So once you have the people in the field with the expertise who can tell you the specifics as to where we are and what the specific measures that are required to be taken, of course, people with legal training can reduce.
If you were contacted, Samson, that you are espousing this on national television, would you be able to assist us? What would your answer be? Yes or no?
Oh, of course. That's
all right.
Very
Thank you for that clarity.
Yeah.
Now, finally, going back to what transpired yesterday in the Supreme Court and moving forward, what is your thinking, about what transpired yesterday? A lot of heckling, a lot of, exchanges between Tsatsu Kata and, the lead counsel, so to speak, yesterday for the petitioner and indeed the members of the bench. What did you make of yesterday's happenings and what are expectations ahead of tomorrow? Very briefly, Samson.
Right. So I go to court every day. I see these exchanges go on. So for those who perhaps are not used to the courtroom and what happens there, they may see things as new and strange, but I don't see anything strange. I don't see anything new. But the substantive issue is that tomorrow the court will deliver its ruling, which ruling may change the status quo. Tsatsu Kata came up against the status quo yesterday, and therefore he had quite a hurdle because by law you don't compel a witness who elects not to adduce evidence to support their case to get into the witness box. In fact, in the ordinary circumstance, you will rather be excited, you will take advantage of that situation and perhaps take steps, including asking that things that person may have filed to be struck out. Or as you have heard repeated over and again, that the witness statement that she brought be put in as hearsay. When your evidence is put in as hearsay, the value is so diminished that using it in determining the strength of your case becomes very terrible. But I say the biggest question that has to be asked at this point is not whether or not a witness should be called to get into the box to be cross-examined, either by the court itself or the petitioner. The question is, supposing, and in fact, the court has power under our Court Act and under our Evidence Act to, on its own, decide that a witness will get into the witness box to speak. But the question is now, what is that witness coming to do? What is it that has become necessary for that witness to get into the box to do. That without which the court cannot make a decision. That is the question. And the ultimate question in the process is, has the petitioner established that the second respondent and the petitioner himself didn't cross the more than 50% threshold? That is the ultimate question. If they have established so in their document, why should another person be called to testify? There would be no need for it.
Right.
And if you need another person to get into the box, who is not your witness, to be able to establish that point, then it does seem to me you have failed from the outset.
Well, this is where we're going to have to wrap it up, Samson. Thank you very much for joining us, lawyer Samson Lardy Anyenene. Tomorrow, the bench will decide, and the conversation, of course, continues. But coming up next on the show, we talk to you about enhancing men's health the Phytotech way. What is Phytotech? Stay tuned and find out.